From WKNOW, this is Steve Chanley with One Question Too Many. Today's program is made possible by the law firm of Employer Advocates Group, serving California employers since 2002, with offices in Orange County and San Luis Obispo County, California. eaglawgroup.com. Joining us today is Michael Naborski. He is a partner at Pryor Cashman LLP in Los Angeles. He is the co-chair of the firm's Privacy, Publicity, and Defamation Practice Group and a member of its Media, Entertainment, Intellectual Property, Litigation, and Digital Media groups. Michael represents media companies, high-profile entertainers, producers, and writers involved in all facets of entertainment and media litigation, including film, television, and publishing. Thanks for joining us today, Michael.
Thank you, Steve. It's a great pleasure to be here.
How long have you been an attorney?
Just over 27 years.
How long have you been with Pryor Cashman?
So I've been with Pryor Cashman 16 years. Before that, I was at a firm called Strook and Levan, which was one of the oldest firms in America until it closed a couple of years ago. I was there for the first 11 years of my practice.
Was that in New York?
So both Pryor Cashman and Strook are New York-based firms. I've worked in the LA office of both Strook and Pryor Cashman. So I've sort of had a New York home base and an LA outpost my entire career.
Tell us about the specifics of your current law practice.
So the way I like to describe it to people is any lawsuit that involves media content. It could be what's said in a podcast, what's published in a book, a song lyric, a song title, an album, something in a film, something in a TV show. If there is a dispute over that media content, I am going to be involved most likely with the defense. The first part of my career, I was predominantly on the plaintiff side. At Pryor Cashman, I've been predominantly on the defense side. So what that does is it sort of takes me into defamation, right of publicity, idea submission cases, copyright infringement. But at the end of the day, it's basically something that you see on TV or a film, hear on a podcast, read in a book, read in an article, or read online. If there's a lawsuit over it, that's in my strike zone.
Was that your practice area when you first began?
You know, it was. I had a very interesting way I came into this practice. At the center of the bullseye of my practice is defamation. I do all of these other areas, but defamation is sort of the core of what I've specialized in. And the way that started was honestly because of a book about the Robert Kennedy assassination in 1968. When I was in law school, I clerked for the Court of Appeal. And there was a judge from the Superior Court who was elevated to the appellate court bench, basically because the Hilton estate was being probated in the Court of Appeal. He was a probate judge, and the Court of Appeal wanted him to handle the appeal. He was also assigned a defamation case, which he quickly gave to me and said, I'll see you at the end of the semester with your opinion. So this was a case where a Pakistani journalist who was in the basement of the Ambassador Hotel in 1968 when Robert Kennedy was shot, holding a camera. Someone had written a book called The Senator Must Die. And in that book, and it was, I guess you'd call it sort of a crackpot book, he alleged that Sirhan was not the real assassin of Robert Kennedy, that it was this Pakistani photojournalist named Khalid Kawar. And so the Globe tabloid, which I'm sure you remember, the supermarket tabloid, published an article saying that Sirhan was not the assassin of Robert Kennedy. It was Mr. Kawar. And Mr. Kawar sued the Globe, and he won at trial. And as you can imagine, the Globe had very good media counsel. Lots of media companies submitted amicus briefs on their behalf. And basically what they were trying to argue was that a newspaper or magazine that writes an article about what's in a book should be protected from independent liability. Maybe the author of the book should be liable, but not the article about the book. And between the justice and myself, we decided that we were going to find for the plaintiff and the respondent. And that case then went up to appeal to the California Supreme Court. 60 Minutes ended up doing a story on the case and on this thing called the neutral reporting privilege, which was sort of a new area of law. And that case was how I got involved in learning about defamation. Now, fast forward to my summer at Strook. At the firm was probably one of the most prominent plaintiffs, defamation lawyers in the world, a guy named Barry Langberg, who has since passed away. And Barry was in the library, and he was representing Steve Wynn, the owner of the Mirage and Bellagio and all the casinos in Vegas. And he was suing somebody based on something that had been written in a book, and then there was a magazine article about it. And so we got to talking, and he said, "Oh, you're the kid that worked on the Kowar case." I said, "Yes." And he said, "What do you think about coming to work for me and do defamation law?" I said, "Yes." And the next 11 years of my career, I worked with Barry and did probably 24 defamation cases. So that's kind of how I got my start.
Hey, that's quite a story. You worked directly for Steve Wynn?
So there was a book published that alleged that Steve Wynn was a frontman for the Genovese crime family in New York. And there was a magazine article written about the book that focused on that allegation. And so Steve Wynn, who was and still is very litigious, sued the author and publisher of the magazine article about this allegation. It went all the way to trial. And it was my first trial, and I did it with Barry. Doing a trial when you're that young, it changes your entire viewpoint of how to litigate a case. Most young attorneys draft complaints and discovery, but they don't see how it ever comes to play out in a trial. So doing a trial before I'd ever actually written discovery responses or done a complaint was very, very educational.
How do you think that shaped the way you practice law now?
It made me much more cognizant of what this case would look like at his trial. I don't know if you remember Vincent Bugliosi. He was the prosecutor of Charles Manson.
Yes.
I've always been a big fan of his writing. I've read a lot of his books. And one of the things he wrote in one of his books was that when he gets a case from the very beginning, he has a legal pad. And he devotes that legal pad to writing his closing argument. And he works on it all the time. He changes it, he adds to it, but he always has that legal pad from the beginning of the case through what he's actually going to deliver his closing argument. And he just always keeps in mind what he's doing at that part of the case, how it will affect the trial. And Barry, my old boss, was very, very accomplished trial lawyer. I don't think a lot of young attorneys have the opportunity to go to trial once a year when they're, the first 10, 11 years of their lives. I had that opportunity with Barry. So I think I'm much more efficient and I don't waste as much time as I think some attorneys do getting bogged down in discovery minutia.
Unfortunately, that takes up the vast bulk of what passes today as litigation.
There weren't billions of emails and texts and those types of things when I started. And also defamation cases tend to have very limited universe of documents. Typically you have a publisher or somebody who has produced an article or a book or a magazine or some content. There's not going to be hundreds of thousands of documents about that. So it's actually very easy to get your arms around the case and try it. And so as time has gone on and I've handled other larger cases, you do get bogged down for literally years in documents. The problem is you have opponents who force you to respond to hundreds of sets of discovery requests and all that. Even if you don't choose to take that path, you're still bogged down.
That's one of the unfortunate remnants of the time-honored way of defending a case, at least in California, of just stonewalling and having a case drag on for 5 or 6 years.
Exactly. Especially when you have a pandemic in the middle of your case.
So one of your cases was a misappropriation lawsuit involving the show So You Think You Can Dance. Would you explain that case to us?
Yeah, so that case falls into what an area I refer to as idea submission cases. I'm sure you and your viewers have read about these types of cases where somebody claims that they had the original idea for a movie or a TV show, and they pitched it to somebody, and then 5 years later, that same show appeared on TV or in a theater, and they sued for what's called idea submission. This was a little bit different. There was and is a guy in Santa Monica named the Dance Doctor, and he teaches dance lessons. And one of his clients was a woman who was married to a guy named Marty Ehrlichman. Marty Ehrlichman had one client, which was Barbra Streisand. And he represented her for 50 plus years without ever having a written agreement. When he pulled up for his deposition, his Mercedes license plate said "from Babs," which I got a big kick. At the dance lesson, the dance doctor gave to Mr. Ehrlichman's wife this treatment for a show called So You Think You Can Dance, and asked her to give it to Marty, to give it to CAA. And so as best as we were able to figure out, Marty's wife came home, gave him the treatment, and he didn't do anything with it. But fast forward 5 years, there is a show that premieres on Fox called So You Think You Can Dance. And it's produced by Nigel Lithgow and Simon Fuller, who were responsible for American Idol. And it becomes a humongous hit. And the dance doctor sues all of the producers and Fox for misappropriating his idea. And we basically settled on the courthouse steps before trial. But it was a very unusual case. We at first thought, two people coming up with the title, So You Think You Can Dance. That's a little odd. But when we dug in, we found about 15 shows around the world that were titled So You Think You Can something. So you think you can cook. So you think you can write. So you think you can do this. So in the end, we made the case that, yes, the titles were similar, but, we had plenty of evidence how Nigel and Simon had come up with this idea on their own. But, as most cases go, they settle, right before trial. So it was a very interesting case. And, one of the things about idea submission cases is somebody who puts their effort into writing, could be a song, it could be a treatment. If they think that it was stolen from them, and then the person who they think stole it made tons of money, becomes a very deeply personal thing for the plaintiff. It's not just a business lawsuit. It is very, very personal. So like defamation cases, when someone's reputation is being harmed, there is a layer of personal animus that goes with it.
You worked on both sides of those types of cases?
Yes. So at Stroke, when I worked with Barry, we were almost exclusively plaintiffs, with a couple exceptions where we got involved sort of on the defense side, which is, I think, one of the reasons why I did so many trials is because Barry was famous for not settling cases. He was a very confident trial lawyer. People often hired him to try cases. I've heard on some of your other episodes you've discussed with guests, these people that sort of parachute in at the end of a case and try a case for somebody else. And that was Barry. People would work up a case, they would lose summary judgment, and they would want to find a real trial lawyer. So they would call Barry, and we would parachute in and we would take the case to trial. And so I probably had a dozen trials in 11 years on the plaintiff side. Since then, I've done mostly defense, basically because of who Pryor Cashman represents. It's mostly media companies and studios. And I've probably had a third as many trials the second half.
I find it interesting that there's a certain personality type that is very much drawn to parachuting into a case that is on the threshold of trial. As near as I can tell, they really enjoy the adrenaline rush of having to pull something together, boil things down to its essence, and try a case before a jury in a very dynamic, simple, and straightforward manner. That seems to be a commonality.
Yes, and I will say this. Once you go through a trial, particularly one where you have celebrities and sort of salacious allegations, and you go through a trial, finishing that and the rush that comes from that, going back to sort of your everyday in the office discovery is a really difficult transition. It reminds me of an interview I saw with Bono from U2, where he described being on stage in the closing concert of the tour, and the next morning being at home sort of, reading bedtime stories to the kids, and the transition it required for him to sort of decompress from that into his regular life. And I think the same thing is true with trial. I think people get, a rush from that challenge. I've had a couple other very significant mentors in my career, all of whom were very hardcore trial lawyers. And I think they have the ability to not have to worry about drafting the document requests and gathering the documents, reviewing them. They only need to really see at a very high level part of the case. So they are able to parachute in and try the case, and they don't have to spend all the time working.
I'm really not one to tell war stories, but I was involved in a pretty high profile case in the late 1990s, as maybe 95. And it was my good fortune to work with an attorney of some renown, Frank Rothman, who I believe was the chairman of MGM at some point. But at that time, he was in his 70s and he was in private practice. He was with one of the very big New York firms. And he was still at that point in his career parachuting in and just getting up to speed very quickly and trying cases. And what I remember is I had interviewed a witness just for purposes of figuring out what information that they had. And I put together a bullet point list of very sparse explanation of the various facts that he would testify about. And Mr. Rothman used that to cross-examine his witnesses. I saw it in his hand. He just used my outline. And I was amazed that he could do that without having all the predicate knowledge that went into that and went into preparing the other aspects of the case. And I've seen other attorneys do this too, where they would get up to speed on a motion that they have to argue, and they would learn the substance of the motion in the cab ride between the office and the courthouse. And they would get up in front of the judge, and they were like performance artists. They would just pull it off. You'd have no idea whatsoever that they just learned the case. So it's an amazing thing to see.
It's not really befitting of my personality. I tend to be very organized and a big planner. So I would find it very challenging to not prepare for several days before an oral argument.
I'm the same way. So I do have a question regarding the submission cases that you were talking about. And I've always been very curious about this, and I'm sure a lot of our listeners are as well. It's not uncommon to hear that someone is suing an artist for misappropriating their idea for a song that came out decades ago. So my question is, isn't there a statute of limitations on bringing those types of claims?
There is, but the law basically provides that you can look back 3 years from when the lawsuit is commenced. And particularly nowadays with the current streaming and availability of catalogs, you may be barred from damages dating back pre-3 years, but you can get it for that window of time.
Fascinating. It wasn't that many years ago that I read, for example, that someone sued Led Zeppelin for Stairway to Heaven because they had composed a song that was very vaguely similar, and it ended up going to trial and he lost. But I was thinking to myself, that came out in the 70s. Hadn't his claim accrued back when he first heard the song?
So our firm is involved in a lot of these music copyright infringement cases, and there's a stable of lawyers basically in New York and LA who handle those cases. Led Zeppelin was defended by a lawyer named Peter Anderson, who is, if not the best, among the very best lawyers I've ever worked with. So Jimmy Page and Robert Plant were in very good hands. But where this started was, I don't know if you recall a lawsuit back, it went to trial in 2013. It was brought by the Marvin Gaye estate against Robin Thicke and Pharrell Williams over the song Blurred Lines. Does that ring a bell?
Yes, not only does it ring a bell, but when I first heard their song, my initial reaction was, hey, they're ripping off Marvin Gaye.
Well, you and the jury were completely aligned. The plaintiff's lawyer who brought that case, we've actually dealt with many times because he's probably the country's leading plaintiff's lawyer in those types of cases. He got a big jury verdict, in that case. And that started a windfall of people coming out of the woodwork and realizing they could recover money, whether it was the artist or their estate. And there started to be a cascade of these lawsuits. We recently successfully defended Ed Sheeran in a case in New York. My partners in New York tried the case, and it was a very personal case for Ed. He got up on the stand, he played his guitar, he showed how he had created a song. And he had basically said, if I'm going to get sued for a song that I created in my head, my heart, and I lose, I'm going to give up music. He was so despondent about it. And fortunately, the jury agreed with us. There has been a pendulum that has swung in the other direction recently. The Led Zeppelin case is one. There was a Katy Perry case, another one, the Ed Sheeran case. There is becoming an understanding amongst judges and jurors that there are really a finite number of pop lyrics and chords and rhythms and melodies that you can come up with. And there are some that are obviously egregious. My personal favorite is Vanilla Ice ripping off Queen and David Bowie with Under Pressure, Ice Ice Baby. But legitimately, there are only so many chords that can be played. And at the Ed Sheeran trial, there was an expert who got up and played a video showing all of these pop songs being played one after the other, sort of blending in. And you can honestly say, oh yeah, they all kind of sound, I see the similarities, but they're obviously different songs. So to answer your original question, people can still recover a fair amount of money in that 3-year look back window, but the cases are very, very, very popular nowadays.
What is the rationale for that 3-year look back period?
I think it's that, if there is an ongoing harm, they want the aggrieved plaintiff to be able to recover something that they would have been able to recover had the infringement started when the song was originally released. I will tell you that there is litigation out there, and there will be appellate court rulings eventually on this to try to expand that window. Obviously, our clients, our firm and our firm's clients who are, the major record labels, watching those cases very, very closely, because it could open up an entirely new world of litigation.
So to my way of thinking, at least equitably, you have people who are sitting on their rights and permitting things that they know about to go uncured. So it goes completely counter to the entire purpose of a statute of limitations. By the time a claim is brought, a song had been produced decades ago, sung decades ago. The people involved may not even still be alive. And if they are alive, they may not have a clear recollection of any of the events that led to the creation of the song. And those concerns underlie the very purpose of having a statute of limitations. So that's why that's always struck me as being incredibly peculiar.
It is. And like the plaintiffs that we discussed sort of in the idea submission cases, artists who created a song, whether it's Stairway to Heaven or, Ed Sheeran with his songs, they don't want to settle a case and have it appear that they stole someone's song. Robert Plant and Jimmy Page sat in a downtown LA courtroom for weeks because they felt strongly enough about defending themselves in their case. And your point is well taken. That is a significant burden for these artists to undertake.
So speaking of Led Zeppelin, they were part of the British invasion post-Beatles that drew very heavily from American blues. So it was Caucasians playing blues music in 1-4-5 progressions and bending notes and singing in a style that wasn't typical of the pop music that was being played. And so for many people who had not listened to blues prior to that, it was a new sound, and it was an exciting sound, and it was the sound of new rock and roll, but it was completely and utterly derivative. So in recognition of the people who inspired them, I know that Led Zeppelin settled cases with blues artists where they willingly paid them royalties as kind of a salute to their inspiration and the importance of their work. They very happily paid those artists. Are you familiar with that?
I don't know the specific cases, but I know that the Led Zeppelin's a great example because they were one of my passions is music biographies. I started years ago and it got put on steroids during COVID. I just love reading memoirs, autobiographies, biographies about musicians, rock stars, groups. And I've read several about Led Zeppelin, and it monetized their success to a level that had never been seen before. And I'm blanking on their manager's name, but he was a force to be reckoned with. And so I think they felt, yes, exactly. And I feel like they felt okay about, like you said, paying that tribute.
I'll just make this one final point and then move on. But I believe that Howlin' Wolf was one of the artists to whom they paid royalties for using some of his work. Particularly his song Killing Floor was fertile ground for a lot of the white blues playing rock artists. So let's get back on track here. Another part of your practice is what I would call First Amendment practice. Would you explain to listeners about that part of your law practice?
Sure. Every media case that we handle has some First Amendment component to it because publishers, authors have certain First Amendment rights to be creative. And so the First Amendment is sort of a thread that goes through all of these cases in some degree greater in some cases than others. One of the things that I do is I work with podcasters to review their podcasts in advance of publication to make sure they haven't said anything or done anything that's triggered concerns about defamation or false light or anything like that. And a lot of the protections that they're afforded to discuss those things are provided for by the First Amendment. So there is a statute in California, which I'm sure you're familiar with, that I don't know if your listeners will be. It's called the Anti-SLAPP statute. And SLAPP stands for Strategic Lawsuit Against Public Participation. And over the course of my career, the Anti-SLAPP statute has been used by media defendants to an extremely high degree to try to dismiss and strike cases brought against somebody over content that they publish. And so that statute has First Amendment concerns embedded in it. And I would say a good 50% of the cases I handle have some anti-SLAPP component to it.
The First Amendment component of that is just the basic right to petition the government for redress. Is that accurate?
That's the first part of the statute. And the second part is anything that's an expression of free speech or expression on a matter of public interest. And most entertainment content will be deemed a matter of public interest, partly because a lot of movies and documentaries and books and, people are writing about things that are a matter of public interest, whether it's public health or crime or corruption. That's what people are interested in. So it's very typical that if something makes its way into a film or a documentary or a podcast, it touches on a matter of public concern. And states like California and now many other states want to provide defendants with protection from lawsuits that infringe on their right to that free speech.
So you used the term earlier, false light. Can you explain that for some of our listeners?
Sure. False light is a very close cousin of defamation. It is often brought along with a defamation claim. Courts will sort of usually collapse them into one. The classic false light case was a case called Solano versus Playgirl. And it was a Playgirl magazine that had a model actor on the cover. And it implied from the cover that he had posed nude in the magazine, which he had not. And so it's because people often see the covers of magazines and don't purchase the actual magazine, particularly something like that. Anybody who passed by the magazine stand would be left with the false impression that he had posed nude in this magazine, and he sued and ultimately was successful. So having his name on the cover wasn't really a statement defaming him, but the law has created this doctrine called false light, where the defendant does something or says something that places the defendant in a false light. The other classic case is the National Enquirer years ago invented an interview with Clint Eastwood. They literally had an interview with Clint Eastwood where it said Eastwood, quote, National Enquirer, quote. They made it up. They never interviewed him. They just created the text of what he was saying. And he sued the National Enquirer, saying that gave people the false impression. It placed him in a false light that he would stoop, in his words, to give an interview to the National Enquirer. And he was also successful. So those are two sort of the paradigm false light cases.
You also handle invasion of privacy cases.
Yes, this is the genesis of this really started with reality TV. We handled a case years ago. I'm not sure if you remember the show Punk'd on MTV. Does that ring a bell?
Yes, I'm familiar with it, but I never watched it.
Sure. Well, the original name of the show is called Harassment. And Ashton Kutcher and MTV and the Hard Rock Hotel in Las Vegas had this idea where they were going to film unsuspecting customers at the hotel engaged in various stressful situations and make that the subject of their TV show. Needless to say, it led to some very unfortunate circumstances. And one of the things that they did was install hidden cameras in people's hotel rooms to film them without their permission. So where invasion of privacy and entertainment met was with the advent of reality TV. Up till that point, you had cases, Dateline NBC with hidden microphones and cameras at a restaurant, but it sort of exploded with reality TV. And there had been cases over the years where somebody was put into a situation without their permission and they were recorded. And obviously it was a very personal affront to them and they brought suit as a result. So that's kind of the area of invasion of privacy that I've handled.
I'm surprised that type of surreptitious recording isn't a crime.
It absolutely is. And if you are a casino in Las Vegas and you have engaged in what is a federal crime, there's a little thing called your gaming license that can be implicated. So that the sort of rogue mentality that was going on there came home to roost in a big way.
One of your well-publicized cases was a defamation case brought against a Buddhist organization, and I'm going to butcher the name here, Soka Gakkai International, that originated in Japan. Can you tell our listeners about that case?
Yes. So this I would say is probably the most interesting / bizarre case of my career. If you'll bear with me, a little background on Japanese Buddhist organizations. Back in the day, there were two sects of Buddhism in Japan. There was one called the Nichiren Shoshu, and there was one called the Soka Gakkai. And each organization was headed by a person of, I would say, not quite at the level of the Pope or the Dalai Lama, but very, very close. Nichiren Shoshu was headed by a guy named Niken Abe, a priest, and Soka Gakkai was headed by a priest named Daisaku Aike. And when the two sects merged, it was never a good, neither side was very happy. And so in the early 90s, a woman named Hiro Klo published an accusation about something that happened in 1963. And what she alleged happened was that Niken Abe, the head of Nichiren Shoshu, came to Seattle for a trip, an ambassador trip. And shortly after midnight, Mrs. Klo got a call from the Seattle Police Department claiming that they were with a Japanese man dressed in robes who had been soliciting a prostitute on the street in Seattle. He did not speak any English, but he had a card on him that had Mrs. Klo's phone number. Mrs. Klo drove to the scene and was told by the police officers that this priest had been soliciting these prostitutes and they wanted to press charges for whatever behavior he had engaged in. Mrs. Klo convinced the police officers that he was this respected priest, that it must have been some misunderstanding. And so the police officers released him into Mrs. Klo's custody, did not arrest him, did not file a report. And Mrs. Klo escorted him back to the Olympic Hotel in Seattle, and that's where it was left. 30 years later, Mrs. Klo published a piece in the Soka Gakkai paper accusing Niken Abe of this conduct, which led to a 10-year battle between the Nichiren Shoshu and the Soka Gakkai. The case was originally brought in California by Mrs. Klo against Nichiren Shoshu for statements they made accusing her of lying, making this up. I won't bore you with the sort of procedural details, but the case was transferred to Tokyo District Court, and we litigated it with Japanese co-counsel. In Japan, there are no juries. It is a judge trial, and the trial court judge found that the statement by Mrs. Klo was true. And so there obviously could not be a defamation, and they found for the Soka Gakkai. In Japan, unbeknownst to me at the time, the appellate process is not just a closed record where you argue appellate legal issues. The appellate court wants and demands additional evidence to support each side's case. So I spent the better part of probably 4 years gathering additional evidence to support this allegation by Mrs. Klo. We hired forensic handwriting experts, lie detector experts. We tracked down one of the 2 police officers who was still alive. We hired psychologists. We hired a very prominent eyewitness identification expert to testify that cross-racial identification could be done by a police officer in the 60s. And it was an absolute spare no expense case. This was a bet the company case, for lack of a better word. Both Nichiren Shoshu and Soka Gakkai viewed this case as proxy as to which one would emerge as the leading Buddhist sect in Japan. And to short circuit in several years of cases, the Supreme Justice of the Tokyo Supreme Court ultimately issued a ruling saying that he was going to fine for Soka Gakkai and that he suggested that Nichiren Shoshu withdraw its lawsuit and essentially go its merry way. They wanted to give Nichiren Shoshu an out so they didn't have an adverse ruling by the Supreme Court. That happened in 2001. And I met some of the most interesting law enforcement people, forensic document examiners. I had multiple polygraph examiners explain to me how polygraphs work. They polygraphed me. And so it was just kind of the case of a lifetime.
How did you get involved in that case?
Well, so my boss, Barry, so just to kind of give you a background on him, I don't know if you recall, but sort of the very first celebrity defamation case was brought by Carol Burnett against the National Enquirer. And Barry was the attorney for Carol Burnett. And that case set the precedent for celebrities suing tabloids and just plaintiffs' defamation in general. As Barry would say, for the rest of his career, people would call him and say, I want the lawyer who represented Carol Burnett. And when the Soka Gakkai were hiring a defamation lawyer for Mrs. Klo, they researched it and they contacted Barry. And that's how we got the case.
Interesting. That's a fascinating backstory.
One of my favorite evidentiary issues from the case was one of the key things in the case was Niken Abe's diary. He claimed that he had written in his diary when he had returned to the Olympic Hotel in Seattle, and that would have proved that he was in his room and he was not out courting with prostitutes. But alas, he couldn't find his diary. Once they lost at the trial court level and the appeal court, he found his diary and he produced it. And on the front of the page was an entry saying, return Olympic Hotel X hour, 8:30. So we had a forensic document examiner examine the diary. And what he concluded was that when you write on one side of a piece of paper like a diary, it makes tiny indentations in the other side. And when you turn the page over and you write on the back of it, each time you write over the letters that are seeping through from the other side, there are tiny little skips over each letter. And so they can tell what was written first, what was written second. And after examining the diary, they concluded that he had written the entry about being back at the hotel after he had written side 2 of the diary. And so it basically impeached him, saying that he had created this entry after the fact. There was an effort by us to take ink tests to prove that the ink he used on that part was done later. But the only way to do that test is to actually physically destroy the diary page, and the court wouldn't allow us to do that. But in the end, the diary turned out to be a very important piece of evidence. So I got to sit there and have that forensic document examiner explain to me the skips on side B of the diary page, which I thought was fascinating.
In that case, which was essentially a bench trial, was it tried before just one judge or was there a panel?
It was a 3-judge panel in the Tokyo District Court, and then there was I believe it was a 6-judge panel before the Supreme Court. It wasn't sort of trial-like. All the submissions to the appellate court were done. They were done on paper. The interesting thing about trials in Japan, they take an incredibly long time because the district court will set a trial date for, let's say, January 15th. They will have 2 or 3 days of testimony. Then they'll adjourn for 6 months, come back in 6 months, take 3 more days of testimony. So it is not a linear process where you have a beginning, middle, end in 2 weeks, and then the judges make their decision. So it's a very inefficient process. That's why it took about, from beginning to end, it took about, I guess, 9 years.
You were on the forefront of attorneys who defended the first wave of libel suits concerning postings on Twitter and other social media platforms. How are social media cases different from other types of traditional media cases?
So it's interesting. You're right. Twitter, I guess I've been practicing long enough where, I've seen these technologies emerge. And I would say on a high level, people that read something on Twitter, they don't assign to it the same level of journalistic integrity that they would if they read it in a newspaper. And so I have handled cases, sort of the earliest ones were on behalf of musician Courtney Love. And she loved to talk about people on Twitter. And she was sued multiple times for things that she said about people on Twitter. And one of them went to trial. And ultimately the jury found that, people just kind of talk off the cuff on Twitter. Can't really take it serious. And so I think the biggest difference between those types of cases and what I would call traditional defamation cases for print media and publishing is people don't assign it the same level of seriousness. And I think people are given more latitude to say sort of salacious things. And that case was in 2009, and I think it's probably only gotten worse since.
The interesting thing is the standardized jury instructions are the same regardless of the type of media. Isn't that correct?
That's exactly right. And one interesting side note about no publicity is bad publicity. One of the cases we defended for Courtney was statements that she made about a fashion designer from the site Etsy on Twitter. And we plotted the tweets. There were probably a dozen. And when she would tweet even negative things about the designer's sales would spike. It would be a huge increase in sales when Courtney was talking about her, even though they were negative statements, which we thought was fascinating.
How was she able to establish proximate harm?
So, ultimately that case settled, and that was a very strong talking point for us in that mediation. Now, she claimed emotional stress and such like that, but it definitely undercut her damages argument. Another one of the cases was Courtney making statements on Twitter about one of her other attorneys. Ultimately, the jury ruled that it wasn't reckless disregard for the truth, and they sort of, after the court case, their take in the hallway was, who believes what Courtney Love says on Twitter? That's it. I mean, after years of litigation and jury trial and jury instructions and deliberation, kind of came down to, who believes Courtney Love on Twitter? And so the more bombastic you are, and I think the more latitude you ultimately get. It's not necessarily fair. And I certainly understand how an aggrieved plaintiff could say, just because you defamed 50 people and nobody believes you doesn't mean you should be able to defame me. But sort of back to the Carol Burnett case. Carol Burnett was accused by the National Enquirer of being tipsy in a Washington, D.C. restaurant and bumping into Henry Kissinger at a table. That was considered defamatory in the late 70s. And nowadays, I don't think that would move the needle on anybody's.
So what's interesting is, and I'm not a First Amendment attorney by any means, but I know that parody is given quite a bit of First Amendment protection. And that might be an example of someone saying something or portraying something other than how it truly is, but yet it's intended to be received as not being the truth. Is that an accurate portrayal?
Exactly. And I'm a huge fan of The Simpsons. I had been for all 30 years of its running. And I think they are an excellent example of parody. They have parodied products, people, or companies. And the intention is obviously for a comedic social commentary purpose. And the law will give the defendant wide berth to that. One case that we handled a couple years ago, I don't know if you remember the song by Rick Astley, Never Gonna Give You Up. So a rapper named Young Gravy, who was born in 1987, he wanted to do a rap song that sampled something from his childhood. So he looked up what was the number one song on the Billboard chart the day he was born. And it was Rick Astley's Never Gonna Give You Up. And so he bought the sample rights to the song and they did a rap song, but they wanted to use Rick's voice to sing part of the song. And they got in touch with Rick and it didn't work out. He was on tour. And so they created what they called a parody of Rick Astley singing part of the song. And it has to do with this whole concept of Rickroll. I'm not sure if you're familiar with that. Even my kids are familiar with Rickrolling now. It is where people take the video of Rick Astley from Never Gonna Give You Up, where he's dancing, and they insert it into a very unpredictable email or text where they say, hey, I'm getting ready to go to do X, Y, and Z. Could you take a look at this and see if I'm on track? And then you click on it and it's Astley dancing in Never Gonna Give You Up. And that's called Rickrolling. And it's just supposed to be a humorous meet. And so we settled that case as well. But one of the issues that was being litigated before the court was whether this was essentially a parody of Rickroll and whether the First Amendment was going to allow Young Gravy and his producers to do this. And again, we settled it, but it would have been a very interesting case to see come to fruition.
Have you ever handled any cases involving deep fake technology that's currently being used?
Yes. So one of the things that started happening, I want to say 2 years ago, could be give or take, was we started seeing people release tracks from what purported to be a famous singer, and it wasn't them. And the example of somebody that we have was Drake. And somebody created a fake Drake song. And obviously Drake and his managers and record companies were aghast and immediately retained us to, demand that these be taken down. And if they continue, there would be litigation. So there is a very real concern from the record industry about people using technology to create fake videos, fake songs, fake endorsements from, right now it was musicians, but it could certainly be anybody.
Have you incorporated some form of generative AI in your practice?
Where we have started to incorporate it is in sort of document analysis, deposition analysis. And this, again, is very nascent stages. Westlaw, there's a sort of a new frontier of legal research. These are all in this sort of test phase for our firm. We haven't really incorporated them across the board yet, but we're sort of learning as we go. And, one of the things that deposition services provide now is after a deposition, instead of having an associate spend hours reading the transcript and summarizing it, it can generate that for you almost instantaneously. I'm sure there are other things that are in sort of test mode right now for the firm. I just haven't used it.
Perform any pro bono work or other charitable work?
Yeah, so I may have mentioned this earlier, but around 2008, I went and I decided to teach. And I did that partly because probably my earliest mentor was my trial ad professor at Loyola, who was an adjunct. He also happened to be the U.S. attorney for the Central District at the time. He then became, in 2020, Joe Biden's Secretary of Homeland Security, Alan Mayorkas. And he was probably the best teacher, professor I ever had. Just a fantastic human being and an incredible teacher. And he inspired me to go back and teach. And so I have participated in a lot of the activities that Loyola offers for pro bono work. Really enjoy working with law students. I feel like even though it's been 27 years, I still feel pretty close to law school. And I feel like the students really enjoy hearing from someone who is actively practicing law. I've had several people, when I ask them, so what are you looking for in a job? They say, I want your job. And by the way, I remind myself of that anytime I get a little down in practice about how fortunate I am. So one of the projects that Loyola does is called the Loyola Innocent Project. And it's essentially a wrongful conviction program that investigates, research, and petitions for release of people who have legitimate claims that they were, prosecuted wrongfully and are factually innocent. So I've done different things over the course of my career, but that has probably been the most rewarding.
Have you ever asked that one question too many?
So I have really enjoyed everyone's answer to this question, and I gave it a lot of thought. And I believe I have an interesting answer for you. I think I have spent my entire career avoiding the one question too many. You mentioned earlier how you didn't want to be unprepared for an oral argument at court because you were afraid the judge would ask you something that you didn't know the answer to. And I had been afraid in deposition and trial that I would ask that one question too many, with one exception. And it actually paid huge dividends. I have not done it since, but I tried a case when I was very young. And the case essentially boiled down to whether the plaintiff's signature on a document was a forgery. And each side hired a forensic document examiner. And obviously the plaintiff said it's a forgery. Our expert said it's not a forgery. Our expert told us that the plaintiff's expert was notorious in the handwriting expert industry for basically saying whatever the plaintiff or party wanted him to say, and that his methodology was very suspect, and that he claimed to have this textbook that was one of the leading textbooks on handwriting analysis. And our expert said you should really look into this textbook because nobody they've worked with has ever heard of it or used it. So we did a little due diligence, and we found, after we dug in, that the expert for the plaintiff had created a shell company. And that shell company was the publisher of his quote unquote textbook. And the reality was nobody ever used this textbook. He created a methodology that was not sound science. And he used it to be an expert in all of these cases so he could say whatever he wanted to say. So at his deposition, I asked him all these questions about his textbook and the publisher. And I got him to say all these things about how law enforcement used it, et cetera, et cetera. And so when I had him on the stand, I led him through all of this. And then I hit him with the corporate records showing that the publisher of the book was a company that he created with an address at his home residence. And there was sort of this stunned silence. I got up, I walked over to the jury, and old me and me of the last X years would have left it at that. But I went and I asked that question. I said, so you mean to tell us, and I sort of pointed to the jury, that you've been lying this whole time? Everything you've told us has been false. And he could have pushed back. He could have said no. He could have wiggled his way out of it. He could have said a lot of things. But he just sat there and stared at us. And I would say it felt like a minute, but it was probably only 3 seconds. And then I sat down. And that, I think, is the only time I've asked the one question too many. And I appreciated your episode with the judge where he specifically recommended that you not ask that question to a witness in front of a jury. But I did, and I think it paid off. So that is probably the only time in my career that I will do it or ever will.
Thank you, Michael. That was an interesting one question too many. Thank you for being on the show. We really appreciate your time. It was a lot of fun.
Absolutely my pleasure, Steve.
Can you tell our listeners how to get a hold of you?
Absolutely. The best way to reach me is to go on our firm's website, www.pryorcashman, PRYORCASHMAN.com. I look up Michael Naborski. My phone and email is on there, and information about my practice. And that's the best way to reach me.
Thank you again. It's been wonderful having you on.
Thank you again, Steve. I really appreciate it.